All right, we are present in case 24-CR 970. This case is captioned State of Ohio versus Tyrone Merritt. Defendant's here. You are Mr. Merritt?
Yes.
He's here present in court with Counsel Rachel Smith. State of Ohio is represented. Hang on a second. State of Ohio is represented by Counsel Amy Alessi and Barbara Zagretsky. All right, we've already had a pre-trial in this matter. The matter was previously scheduled for trial. It was continued. Very recently, the court learned, as well as everybody else, that the defendant's attorney, Mr. Mariotti, is no longer able to practice law. I think we learned that just 2 weeks ago, maybe not even 2 weeks ago. My notes show March 19th. You were advised of that at some point, I'm assuming, Mr. Merritt?
Yes, when I got a call from Bill Watson.
Oh, so that's how you learned of it, when
Yes,
you got a
that's
call from
how
the public defender's office?
Yes, and I haven't talked to Mark Mariotti since. And
No one from his office contacted you to let you know that?
Nope. I had paid him, and just can't get it.
Well, obviously I can't do anything or address that. It's something you're going to have to do on your own in that regard. Excuse me. But as soon as we got notice, we did appoint the public defender's office to represent you at that point. And you're more than welcome to proceed with them. They're excellent lawyers, and I'm confident you'll be fine there. But I had heard, I guess, that you had indicated you wanted to hire another lawyer, or at least going to look into that. And you don't have to. Well, I guess you do have to tell me, because we need to schedule something. And I want to give you time, but we can't. None of this was your fault. I get it. I'm not going to, punish you in any way or make this hurt you in any way. But we do need to get moving along here. And what I can't have is to go ahead, schedule this with Ms. Smith and Mr. Watson. Both of you guys will be representing. And then get right up to the trial date, and all of a sudden you bring a new lawyer in at that point, saying, I have a new lawyer and I need to continue this again. So if that's something you want to do, that needs to be done ASAP in terms of getting a new lawyer.
Okay.
You
Well,
understand
that? I understand what you're saying. At the same time, it's I'm annoying. To be honest.
It has nothing to do with us.
Yeah.
You understand that, right?
Yeah.
I mean, this issue with Mr. Mariotti has nothing to do with the courts, the prosecutors. I don't even know what it was about. I have no clue. I didn't know anything was pending. I don't know anything.
Okay.
So, I mean, I get being annoyed, but annoyance shouldn't be directed towards the court or the prosecutors or the public defenders or anyone here in the system. That should be directed at one person only, quite frankly.
Yes, and honestly, I'm not giving off no irritation. I'm just.
You're not. I just. We're all on the same page here. So I need to set this for a new trial.
Yes.
Your lawyers filed a motion to continue as soon as they were appointed because they just got on the case. And when was the trial set? This week or next week or something like that? Very soon. April 1st. So set for tomorrow. So they filed a continuance, which I granted. When we need to get a new trial date, I guess I want to. Do you know what your intentions are at this time in terms of counsel? Are you going to go to the public defender's office? Are you going to look for a new lawyer, or?
Like I was saying, I'm really annoying at this moment. So if we can set a trial date and just.
I'm going to set a trial date. So I'll just make it clear.
Okay.
You may not know an answer to that yet, and I get that too. But I'm going to set a trial date, and I'm going to give the public defenders enough time, sufficient time to be able to prepare so they're ready to go. I'm not going to make them go to trial in 2 weeks and rush them through. They're going to get time to do what they need to do. But what I'm not going to be able to allow is when we get a week before the new trial date, all of a sudden you get a new lawyer that enters an appearance and then wants another 2-3 month continuance. That's not going to be able to happen.
Understood.
Okay. All right. So, Ms. Smith, how much time would you believe Have you gotten a discovery yet? I mean, I know you just got on board, what, 10 days ago, 11 days ago, 12 days ago? But.
Your Honor, we are in receipt of discovery, and after talking with Mr. Watson, 4 to 6 weeks would be reasonable.
Is there anything the state wants to add here at this point?
Are we going to discuss scheduling further after this? Or is this? The co-defendant's trial is set for June 9th. Do you plan to file a motion to join the trials? This is the lower case number. And so it would
Why wouldn't that have been done a long time ago?
The co-defendant was, we could not get the co-defendant. So I did not know when we would get him. He was being
Well, he wasn't, you couldn't get him, he wasn't in custody or arrested or?
Right, well, he was in custody in Cuyahoga County, then he was sentenced to prison, and we brought him from prison.
Who has
within
this
the last
case?
month. Judge O'Donnell. So when we were originally scheduling trial dates for this case, I did not have the co-defendant's case here. It was just a warrant for his arrest, and I didn't know when that would happen.
When are you gonna file a motion?
Today.
Because I'm gonna give the other side up. I mean, I don't know any of the facts here, whether it's something that's appropriate for.
I did tell both defense counsel in this case and co-defendant's case that I was going to be doing it.
Who represents the co-defendant?
Chuck Langmack?
Is he retained?
No, he's appointed.
Did you have the public defender's office initially and then got Mr. Mariotti?
Yes.
No. That's why you got involved.
Your Honor, we would need time to respond
Sure, I
to
did.
the state's motion because there would be an opposition to joinder in this case due to adversarial defenses.
Okay. When's that trial date?
June 9th.
When was he arraigned? What's his name?
The co-defendant, Clark Williams.
What Williams? Sorry.
Clark Williams.
I can look it up here.
March 14th.
That's just 2 weeks ago. All right, well, I'm not going to schedule right this second. Let me get the motions and go from there. I'm assuming, though, you've been starting to prepare, or going to discovery
Your
at
Honor.
least. But we are probably looking at, just so you know, we're going to be looking at, Mr. Mayor, so you know that it's going to be like the 4 to 6 range, probably more closer to the 6 range that your attorneys are talking about. We'll get a specific date for you, but that's the range I'm talking about. So I guess the point I want to stress here is if you are going to get a new lawyer, you need to start working on that immediately. So if that new lawyer comes on board, it's not going to interfere with the trial, a week or two away. Because if he comes on board with, with only a week or two left, he's not going to have enough time to prepare. I'm not going to be inclined to grant a continuance at that point if it's last second that he comes on board. All right? Any questions for me?
No.
Ms. Smith, is there something you want to add?
Just for the court's awareness, Your Honor, Mr. Merritt will be meeting with Mr. Watson and I at the office after this hearing, and I think that he will be better able to make a decision as to his representation.
All right. All right, and then if the state's going to file a motion, get that filed as soon as possible.
Yes, Your Honor. I will file
All
it
right,
today.
anything else for the record?
No, thank you.
All right, thank you all.
All right.
through your attorney, but you need to talk to your attorney, obviously, 2 weeks before the trial date as to whether it's going to be a trial or whether you're going to enter a plea to something. So 2 weeks before the trial date here is April 15th. So your lawyer will need to advise the court on or before April 15th as to whether this is going to be a trial or whether you're going to enter a plea of guilty to some charge. If it's going to be a plea of guilty to some charge, it'll be before the 29th. We'll schedule it within that 2-week period. Obviously, I don't know that yet, so I can't give you a date for that right now. But it's your responsibility to find that out. So if you decide you're going to enter a plea, you're being advised that it'll be before the 29th, and you need to make sure you know when that is. And if you don't receive any notice, you need to reach out to the public defender's office and find out when that is. Coming in here and saying I wasn't notified, nobody told me, I didn't get anything, that's not gonna cut it. It's your responsibility to find out when that is. You can go on the docket and find that out also online. But just be aware that if it's going to be a plea, it'll be before the 29th, and that'll be their next hearing date then. All right.
Thank you, Your Honor.
Okay. All right. Is there anything else for the record, Ms. Mulligan?
No, Your Honor, thank you.
Ms. Tomazik?
No, Your Honor, thank you.
All right. Thank you all.
We are hearing case 24 CR 1163, State of Ohio versus Marquise L. Watkins. Present in court is the defendant, who's accompanied by his attorney, Ms. Nicole Novotny. We were previously here on February 24th, 2025. At that time, the defendant withdrew his previously entered plea of not guilty and entered a plea of guilty to count 1, tampering with evidence, a felony of the 3rd degree in violation of Revised Code 2921.12A1, and count 3, improperly handling firearms in a motor vehicle, a felony of the 4th degree in violation of Revised Code 2923.16B, with a forfeiture specification. This matter was referred to the Lake County Adult Probation Department for a pre-sentence investigation report. That report has been completed. The state has had an opportunity to review it and is ready to proceed with sentencing. The state would move to dismiss the remaining count of the indictment, and there are 30 days of jail time credit.
Thank you. Ms. Novotny, any reason not to go forward with sentencing?
No, Your Honor, we may go forward.
Anything you'd like to say on behalf of your client?
Yes, Your Honor, we would like the court to consider community control sanctions at this time. I know I've had a long conversation with Mr. Watkins regarding this case and how the situation could have been different. Ultimately, he is disappointed in his reaction to how he handled himself on this day. I know the length that he's been incarcerated up until now has been very eye-opening for himself. I know his family's in need of him, his job's in need of him, which were showed through character letters that were presented to the court. Ultimately, he does have a 6-month-old daughter that he cares for. I know he's never been away from her this whole long time. He's ultimately always been there for her since she's been born. With working from home as an insurance agent at Family First Life, he's been there for not only his girlfriend, his daughter, but his family as well. Your Honor, he's also graduated from high school in 2015. He did attend 4 months at West Liberty University on a football scholarship. Unfortunately, he had a shoulder injury ending that stint in college. He does have 30 days of credit. We'd just like the court to consider any type of leniency with considering community control sanctions at this time. Thank you.
Thank you. Mr. Watkins, you have the right to address the court before you're sentenced. You can say anything you want. Is there anything you want to say at this time?
Yes, sir. First, I'd like to say good morning, Judge Culotta. I have a few things to say. Excuse me if I stammer. I'm kind of cold. But firstly, I'd like to say I definitely have learned my lesson from this incident. This is something that could have been avoided completely. From my lack of understanding it is the reason why I'm in this position in the first place. So yeah, like I said, the first thing is just to assure you that my lesson has been learned. These last 26 days have been nothing but a lesson for me to sit down and actually reflect on the choices that I made prior and reanalyze everything that I've done. My thought process prior to this, it has been changed. Like I said, me having firearms was something that I thought was to protect myself. And I understand now that in all actuality, it just made me appear to be something that I'm actually not. I was trying to protect myself from a certain type of people, and it seems now that I'm appearing to be that type of individual myself. Since I was old enough, like I said, I have carried firearms for that reason. And that was just because of my own limiting belief. But through sitting for these last 26 days, like I said, I do understand where I went wrong and things of that nature. And this misfortune definitely was a lesson for me to be, a lesson to be learned. Like I said, though, my perspective definitely has changed. Prior, I said that I did not commit a crime, it was an infraction, and that's just from a lack of understanding on my behalf of the law, to be completely honest with you. So from the last 26 days, I've been able to sit and reanalyze that as well and come to a better understanding that, like I said, me having firearms wasn't necessarily protecting me from the individuals I thought it was. It was putting me in a position where I am putting my family at lack. That's not something that I'm here to do at all. Like I said, I'm a father now, but I do believe this unfortunate circumstance was something that needed to happen. I needed to sit down, I believe, for these 26 days to kind of give me a different understanding. I'm not sure if I would have had that understanding had this incident not happened. So that's something that I am appreciative of. Like I said, I don't want you to judge me on this particular incident. I want to be judged more so based off the merits of my character, If you talk to anybody that I've been in contact with, pertaining to this case, I'm pretty sure they would all vouch for me for being, the same individual throughout the whole thing. I'm not trying to portray myself to be something that I'm not. Yeah, so like I said in the beginning, as I stand before you here, I just want to assure you that my lesson has been learned. I guarantee if you were to see my name again, it would be more so in a positive way, and you'll be able to say that you helped set a young individual back on the track that I needed to be on. So all I ask from you is your mercy. I ask to be given another opportunity to show my honor as a man, that I'm a man of honor, and that this incident that I'm in currently will not be repeated again.
Thank you, sir. Mr. Martin, anything else
No, Your Honor.
for the state of Ohio?
Thank you, Your Honor. The defendant does have prior marijuana and weapon charges in his juvenile and adult criminal history. He was on probation at the time this offense was committed, and his bond was revoked in this case due to his continued use of marijuana. For these reasons, and based on the facts and circumstances of the case, the state is recommending that the defendant be placed on community control sanctions with local jail time as well as treatment. Thank you, Your Honor.
This court has reviewed the pre-sentence report and investigation. I've considered the facts and circumstances of the offenses involved here, the nature of these offenses. I received several letters in support of the defendant. I've read all of those and taken those into consideration. I've considered what's been said here in court today by the defendant himself, his lawyer, the prosecutor, the recommendations from the parties. All this is considered by the court in light of the purposes and principles of felony sentencing set forth in 29-29-11. For the factors in 29-29-12, factors indicating the conduct is more or less serious. The court notes that there was a young, small child in the vehicle at the time that this offense occurred, somewhere in the range of approximately 3 to 4 years old. When the car was stopped and the officer approached with a strong odor of marijuana in the car at the time, and as well as the firearm. But the young child being present makes it more serious. Nothing makes it less serious. For recidivism factors, the court finds the defendant was on probation in Cuyahoga County for a weapons charge at the time this offense occurred. So he's carrying a gun, smoking marijuana when he's on probation to Cuyahoga County. He's got criminal history, juvenile marijuana charge, but then this is his third conviction as an adult, and they're all weapons charges. This is his first felony. He's not responded favorably to previously imposed sanctions. While he may not have been violated in Cuyahoga County, he still committed a new felony while he was on probation. Smoking marijuana while he's on probation. There's a drug abuse problem here that the defendant doesn't recognize. You've been smoking marijuana every day for 12 years, and you don't think you have a problem with marijuana.
Can I speak?
Sure.
Yeah, no, I do. I understand that I have an issue with marijuana.
Well, I don't know. You told probation you did it, and I can read it to you. So you don't have any problem with marijuana?
But that when I went to talk to the probation officer here, I did state that I know I have an issue with marijuana. Like you said, I have prior gun charges. Everything that I have pertaining to law is dealing with marijuana.
Yeah, you're on bond with a condition of no marijuana, and you still smoke marijuana, knowing that if you violated your bond would be revoked, you'd be go to jail, and you did it anyway. So I don't know how you don't think you have an issue with that.
No, I do. That's what I'm saying. I do have an issue with marijuana. I do. That was something that I stated talking to the probation officer. I understand that I have an issue with marijuana. And I understand where it's, like I said, it's putting me in this position. Me carrying firearms has put me in this position. Me smoking marijuana has put me in this position as well.
Yeah, from the pre-sentence report, it doesn't appear there's genuine remorse. Now, the defendant's addressed this here today, saying, but these comments that he's made about, I don't even know what it means, to be honest with you. What did he say? I committed an offense, but didn't commit a, here it is. Defendant stated he broke the law, but did not commit a crime. I don't know what that means.
May I speak?
Sure.
Like I said, that was just from lack of understanding at the time. I understand.
Lack of understanding what?
Of the law, to be completely honest with you. And what I was saying is, just from my perspective at the time, I didn't have any malintentions with, using firearms. Like I said, it was just something for protection. It's not like I meant to do harm or anything like that on anybody. It was just something that I had to protect myself. And that was just a limited belief. Like I said, I thought that I was protecting myself from certain individuals, and I appear to be that type of individual, to the courts. It's not my goal at all.
Well, you clearly knew you weren't supposed to have a gun because you hid it from the police. One of the charges here with tampering. You wouldn't. You hid it when you were pulled over. You lied about having a gun. You wouldn't give them the key to open up the glove box so you can give them the gun. They had to find it themselves. So you clearly knew you weren't supposed to have it.
Can I speak?
Sure.
Yeah, so like I said, when the whole incident happened, I reached into the glove compartment to grab paperwork or whatever the case is to give to the officer, and I realized the firearm was in the car.
And so how'd the key end up down your pants and your underwear?
Yes, I did do that. That part I'm not, I take full accountability for that. But like I said, the whole point, the firearm being in the car initially was not something that was meant to happen at all. It's not something, like I said, I understand. I think 2 months maybe from getting off probation. I get off probation for the case that I just had, or that I'm currently on probation for in April. So I understood that I wasn't supposed to have firearms, and I hadn't been carrying firearms. But we had just moved into the apartment that we are in, and within that moving, the firearm ended up in the glove compartment. And when I realized it was in there, I understood where, you know what I'm saying? And I'll be honest, it kind of scared me dealing with the law.
Well, where was the gun supposed to be?
In my mother's possession.
Why'd you have it?
Because like I said, we were moving, and
Who was moving?
Me and my girlfriend from my mother's house to.
All right, so why was the gun in your car?
From moving from our house to.
He says your
house.
mother's gun.
No, it was my firearm, but I'm saying I was moving.
All right, I thought you said it was your mother's gun.
No, it's supposed to be in her possession. I understand I wasn't.
So how did it end up in the glove box?
From moving.
Who put it there?
Myself.
There's no factors here indicating recidivism. As far as recidivism factors, the court also notes the defendant violated his bond by using marijuana on bond, which is a factor indicating recidivism is more likely. Nothing indicates recidivism is less likely. Count 1 is a felony of the 3rd degree. There's no presumptions for probation or prison. Court could order either without making any findings. Court finds that with the defendant being on probation to Cuyahoga County at the time he did this for a weapons charge, a prison would be consistent with the purposes and principles of sentencing. And we'll make a finding, however, at this time that defendant's amenable to an available community control sanction. Place the defendant on community control sanctions for a period of 2 years, but one, there's gonna be consequences. Two, there's gonna be treatment that's ordered that needs to get addressed before the defendant's on his own. I'm gonna order the defendant, again, 2 years community control, is gonna serve 90 days in jail with 30 days of credit. I'm gonna order that he enter and successfully complete the jail treatment program when he's in jail, as well as the decision points program. Further conditions, you're not to have any drugs or alcohol. You must submit random urine screens. They must be negative. Positive screen, even for marijuana, is a violation. You're not allowed to use marijuana or any drugs. 2 AA meetings a week with the sponsor. Obtain and maintain full-time employment or education. Pay your court costs and supervision fees. And order the forfeiture of the items and property set forth in the forfeiture specification. Follow aftercare recommendations from JTP. Take all medications as prescribed. 1 doctor, 1 dentist, 1 pharmacy. If you have a specialist, that's fine too, but probation needs to know who the doctors are that give you prescriptions. You can only get them from that physician. You can only get them filled at that pharmacy. Mr. Randazzo, anything else I'm omitting here I should think about for probation?
Nothing further, Your Honor.
Mr. Walker, do you understand the conditions of your community control sanctions?
Yes, Your Honor.
Any questions for me?
No, Your Honor.
I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from this court, or if you commit another crime while you're on probation, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, it would be 36 months on count 1, plus an additional 18 months on count 3 to be served consecutive, so it's 4.5 years in prison hanging over your head. You understand that?
Yes, Your Honor.
Another condition, so we're clear on this, you're not to possess, own, have in your possession any firearms. Understand that?
Yes, Your Honor.
Similar, anything else for the record?
Just to dismiss the remaining counts, Your Honor, and bond.
Bond will be released, whatever was posted, I'm not forfeiting bonds, the bond's released and dismiss count 2. Ms. Novotny, anything else?
No, Your Honor.
All right, thank you.
Your Honor, we're here today in the state of Ohio versus Blake Grubb, case number 24-CR-1235. The defendant is present with counsel Nicolette Tomazik. We're set today for a change of plea hearing. A 2-count indictment was filed in this case on February 28, 2025. It's the state's understanding the defendant is going to withdraw his previously entered plea of not guilty and enter a guilty plea to count 2, receiving stolen property, a felony of the 4th degree in violation of Revised Code Section 2913.51A. If that plea is forthcoming and accepted by the court, the state would move to dismiss the remaining count at sentencing. The state would also ask for a pre-sentence report and psychiatric evaluation, and there is no agreement as to sentencing at this time. Thank you.
Thank you. Ms. Tomazik, does that sound accurate?
Yes, Your Honor, that is accurate.
Mr. Grubb, were you able to hear what the prosecutor had to say regarding what she believes your intentions are here this morning?
Yes.
She indicated to the court she believes it's your desire to withdraw your previously entered plea of not guilty and enter a plea of guilty to count 2 of this indictment, charge of receiving stolen property, a felony of the 4th degree. The remaining count would get dismissed. We would then defer sentencing and order a pre-sentence report and investigation. Come back on a future day for sentencing where there's no agreement between the parties regarding any recommendations. Each side is free to recommend to the court whatever sentence they believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, and most importantly, what you want to do here at this time?
Yes.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties that you face. So for me to determine all these issues, I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to speak with your lawyer to ask her questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything we're doing here, all right?
Yes.
All right. Well, let's get started then. How old are you, sir?
35.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came into court here this morning, have you had any drugs or alcohol of any kind?
No.
What about within the last 48 hours?
No.
Not even prescribed medication, nothing?
Nope.
Now, you would have been served with a copy of this indictment. You probably got it right at the beginning of this month, beginning of March. It's a document that sets forth the specific charges you're accused of committing. Do you remember getting that?
Yes.
And at some point, did you have the chance to look that over?
Yes.
Now, in that indictment, there are 2 counts. Count 2 is the charge you're pleading guilty to, and what's alleged here and what you'll be admitting to is on or about October 10th, 2024 in Mentor Lake County, Ohio, that you did receive, retain, or dispose of certain property, being Ace Hardware merchandise, the property of another, Ace Hardware, knowing or having reasonable cause to believe that that merchandise had been obtained through the commission of a theft offense. It's further alleged the value of this property was more than $7,500, but less than $150,000, which makes the offense receiving stolen property a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in regards to count 2?
Yes.
Any questions about it?
No.
Now, there is another count of this indictment of theft that's being dismissed. Is that your understanding?
Yes.
Any questions about that charge?
No.
Well, then before I can accept your guilty plea to count 2, I need to make sure you understand all the rights you are giving up. And you first of all have a right to have a trial in this case. And that trial could be to me as a judge, where I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. And a jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by the jurors would have to be a unanimous decision, which means all 12 jurors would have to agree together, one way or the other, whether you're guilty or not guilty of the charge. Do you understand that?
Yes.
Do you understand by pleading guilty you're giving up your right to have a trial?
Yes.
Now, if we had a trial, the prosecutor here would be representing the state of Ohio, and she would have what we call the burden of proof. Having the burden of proof means it's her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of this charge, and that presumption of innocence sticks with you and stays with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes.
Now, when we speak of this burden of proof, since it's a criminal case, the burden of proof is what we refer to as proof beyond a reasonable doubt. And that is the highest burden we have in our justice system. What it actually means, it's the amount of the evidence and the quality of the evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charge beyond any reasonable doubt before you could ever be found guilty. Do you understand that?
Yes.
You understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes.
Now, in order to try to do that, if we did have a trial, the prosecutor would call witnesses that come to court to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions, and that's called cross-examination. She could ask them anything she wanted to, within certain rules. Do you understand that?
Yes.
You understand by pleading guilty, you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you want. Do you understand that?
Yes.
And you further can request the court issue an order, and we call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they weren't willing to come in voluntarily on their own. Do you understand that?
Yes.
You realize you're giving up that right.
Yes.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here is not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes.
Further understand that if we did go to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes.
All right, well, do you have any questions at all regarding these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No questions.
Do you understand them all?
Yes.
Do you still want to plead guilty?
Correct.
You understand your guilty plea is a complete admission of guilt. It means you're admitting to the facts being alleged by the prosecutor, and we're not going to argue that you didn't do this or it's someone else's fault or anything like that. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of that plea is you'll be found guilty by the court, and then you will subsequently, on a future day, be sentenced by the court. Do you understand that?
Yes.
Now, as far as sentencing goes, you're pleading guilty to a felony of the 4th degree. This offense is punishable by a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes.
Now, are you currently on probation or parole or any type of supervision in any other courts or agencies?
No.
Do you have any other charges pending against you in any court?
No.
If a prison sentence is imposed in this case upon your release from prison, you could be placed on what we do call post-release control, sometimes referred to as parole. It's a period of supervision you would be on after you served and completed the prison sentence. And in this particular case, it could be for up to 2 years. Do you understand that?
Yes.
And if you were on post-release control and are violating the conditions of your supervision, we would have a hearing to see if you're what's called a probation violator. And if it was determined that you were, I could extend your probation up to Up to 5 years? Oh, you're right. I'm sorry. Thanks, Mary. Let me back up. Got my supervision mixed up. If you're on post-release control, that's supervised by the adult parole authority, not the probation department. And if you're on post-release control and you're violating the conditions, the parole authority could send you back to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by this court. Do you understand that?
Yes.
So the court's not involved in that at all. That's all through the adult parole authority. You understand that?
Mm-hmm.
Okay. Now, aside from the possible prison sentence I just mentioned, there are other sanctions that I could order. You could be fined, in this case, up to $5,000. You could be ordered to pay court costs. You could also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment, if any that were applicable in this case. Do you understand that?
Yes.
Further, you can be ordered to pay restitution to the victim for any economic loss any victim may have suffered as a result of the criminal conduct involved. Do you understand that?
Yes.
Now, a few moments ago, I explained the possible prison sentence you face. I used the word possible because prison's not mandatory or required in this case. You are eligible for probation, or what we refer to formally as community control sanctions. Do you understand that?
Yes.
Do you understand that just because you're eligible doesn't mean you'll automatically be put on probation? It means I'll consider that if that's what you're going to be asking for. I'll look at all the information presented to the court. Then I'll make the decision that ultimately I think is the right thing to do. Do you understand that?
Yes.
Now, if you are put on probation, it could be for up to 5 years of supervision. And as the judge, I do have the discretion to order a wide variety of rules and conditions for you to follow. One of those conditions could be an order that you serve a term in the Lake County Jail up to 6 months as a condition of your probation. So even if you're put on probation, doesn't automatically mean there's no jail time. It could be incarceration locally in the Lake County Jail as a condition of probation. You understand that?
Yes.
Further, if you find yourself on community control sanctions and you never violate any of the conditions, we would have a hearing. This is what I was saying before by mistake. We would have a hearing to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, again, it could be anywhere between 6 to 18 months in prison, and that could be consecutive to any other prison sentence you may be serving at that time for some other case, or that you're being sentenced to on some new case. You understand that?
Yes.
Lastly, when we do come back here for sentencing, you're going to have the right at that time to say anything you want, anything you'd like me to know or consider. Your lawyer could speak on your behalf. She can recommend the sentence to the court. The prosecutor could also recommend the sentence to the court. Do you understand that?
Yes.
To understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what it says, a recommendation. I don't have to follow that if I think it was the right thing to do. You understand that?
Yes.
All right, are there any questions for me at this time regarding anything we've just talked about, the rights you're giving up, the penalties you face, what you're pleading guilty to?
I do not.
Do you need any more time to talk to your lawyer before we go forward with your actual plea?
No.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the evidence would show if we had a trial. I want you to listen to what she says because I'll have some follow-up questions for you, all right?
Mm-hmm.
All right. Spell?
Thank you, Your Honor. Had this matter proceeded to trial, the state would have proven beyond a reasonable doubt that Blake Grubb was an employee of the Ace Hardware in Willowick. His employer became suspicious that he was taking merchandise without paying for it. They contacted the Willowick Police Department, who obtained a search warrant for Mr. Grubb's home in Menor Lake County, Ohio. During the execution of that search warrant, the missing Ace Hardware merchandise was located, the value of that merchandise being more than $7,500, but less than $150,000. And that search warrant was executed on October 10th, 2024.
How much was the property?
We're still figuring out the exact numbers, but we're looking at around $12,000.
What period of time did this cover? Approximately?
September 2024, the whole month we have security footage, but I can't say exactly when the theft started.
Like a month period of time or so?
But it was found on that October date.
I get that.
Yeah.
Mr. Grubb, were you able to hear what the prosecutor had to say regarding what she believes the evidence would show if we did have a trial?
Yes.
What, if anything, did you say about those facts as she presented them? Are they true? Did you do what she said?
Yes.
Very well, then regarding count 2, charging with receiving stolen property, a felony of the 4th degree, what is your plea to that count?
Guilty.
All right, I have in my possession at this time a document called a written plea of guilty and judgment entry, which explains everything I've just gone over with you. Before I can accept your plea, I need to make sure you understand this document and what it says, and that you sign it here in open court. Now, my understanding is before I came out here, you had a chance to go over this document with your lawyer. Is that correct?
Correct.
Ms. Thomas, is that accurate? Did you review this with Mr. Grubb and answer his questions?
That's correct, Your Honor.
Did he indicate an understanding of it to you when you did that?
Yes, he fully understood it, Your Honor.
Is that correct, Mr. Grubb?
Yes.
Do you have any questions for me about what it says?
No.
It also appears that you signed this document. Did you in fact sign it?
I did.
Did you witness that, Ms. Thomazik?
Yes, Your Honor.
Ms. Bell, you as well?
I did, Your Honor.
Very well, then, at this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, and voluntary waiver of those rights. The court also finds the defendant does understand the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, find the defendant guilty of count 2, receiving stolen property, a felony of the 4th degree in violation of 2913.51 of the revised code. Count 1 will get dismissed at sentencing. Sentencing will be deferred. In order pre-sentence report investigation as well as a victim impact statement. Any issues with drugs or alcohol that need to be explored, Ms. Thomazik?
No, Your Honor.
Okay, so just those 2 evaluations. So what all this means, I'll continue bond and owner cognizance. Are there any conditions of bond?
I don't believe so.
Order A, no contact with victim. So what all this means, Mr. Grubb, as far as bond goes, I'm continuing your bond. You've already, your bond's an OR bond, which means you signed the form and your signature is your bond. I need to advise you, you probably were advised of this already, but when you're released on an owner cognizance bond, if you fail to appear at any future court dates, that's a separate felony, which is actually the same level of what you just pled guilty to, that you would be prosecuted for. You can receive an additional 18 months in prison on top of whatever would happen in this case. So it's obviously important you show up at all future court dates. And the sentencing in this case is when, Mr. Shadowman?
5/5 at 1:15, sir.
So May 5th at 1:15 will be your next hearing. That's what you need to show up for. Now, before that, there's going to be some other things you need to take care of. I'm referring you to the probation department so they can prepare these reports. So the purpose of the report is so I can learn more about you before sentencing. The way they get the information they need to prepare the report is they're going to conduct an interview with you. It's important that when you meet with them that you're open and honest with them because they're going to check and verify everything you tell them. And if they learn that somehow you're misleading them, whether it's flat out lying or even just minimizing something or exaggerating something, they're going to let me know that and I would consider that as sentencing. You understand that?
Yes.
All right, so you're going to leave here right now. You're going to go directly to the probation department, fill out some initial paperwork, and get your dates to go back there for that interview. So make sure you go there when you leave here, and then make sure you show up when you're supposed to for that interview. Because if you don't show up and they can't do the interview, then they can't prepare a report. And by law, without a report, I can't consider probation as an option. You understand that?
Yes.
All right. Anything else for the record, Ms. Bell?
Nothing further, Your Honor. Thank you.
Ms. Thomas?
No, Your Honor, thank you.
All rise.
All right, we are present in case 23 CR 317. This case is captioned State of Ohio versus Landon Reynolds. We're here on a motion to terminate community control sanctions. Then was initially placed on community control sanctions by this court. Motion to terminate those sanctions has been filed. Been previously waived probable cause. And we're here for the final hearing. Defendant is in court with his attorney, Mr. Malcolm Douglas. Mr. Douglas, what's the defendant's intentions at this time regarding the final hearing?
Your Honor, the defendant would admit the behaviors that bring him before the court.
So he's going to waive the hearing then?
Absolutely.
Okay. Mr. Reynolds, you have been charged with violating the conditions of your community control sanctions. Specifically, it's alleged that you violated two separate rules. The first rule is Rule 8, which prohibits you from using, possessing, or having under your control any controlled substance not prescribed to you by a licensed physician. And it's alleged that you tested positive for marijuana back on September 3rd of last year and the 17th, as well as November 5th of last year. So 3 separate positive screens. It's then alleged you violated Rule 3, which requires you to report to your probation officers at times and dates as directed. And it's alleged you didn't report for your scheduled probation appointment on November 19th and you failed to appear thereafter. Now you have the right to have a final hearing regarding these allegations, and that's a hearing where the prosecutor will be required to prove the actual merits of what they're alleging. Now you can have that hearing, or you can waive the hearing and plead guilty to the violation. And your attorney has indicated he believes you want to waive the hearing and admit to the violation. Is that correct?
Yes, Your Honor.
Well, before I can accept your waiver and your admission, I need to make sure you understand the potential penalties you face if you are found to have violated your community control sanctions. If in fact that did occur, the court could extend your probation up to 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, it could be anywhere between 6 to 18 months on count 2, plus an additional 6 to 12 months on count 1, for a total of 30 months in prison if I ran them consecutive. So do you understand the potential penalties you face if you are found to have violated your community control sanctions?
Yes, Your Honor.
Well, having been so advised, what do you want to do at this time then? Do you want to have this final hearing, or do you want to waive the hearing and plead guilty to the violation?
Waive the hearing and plead guilty, Your Honor.
Very well, then as to the allegation that you violated Rule 8 by using marijuana, what is your plea to that?
Guilty.
As to the allegation that you failed to report to your probation officer since November, I believe it was the 19th, what is your plea to that?
Guilty.
All right, the court will accept your pleas of guilty, find that you did violate your community control sanctions. Mr. Douglas, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Yes. Your Honor, this case is an instance that sort of bothers me. The defendant is 21 years of age, and even though he is an adult, he's a neophyte adult. I have a son who is 21 years of age as well. And in looking at this, in talking to this young man, and I've given him a fairly strong and stern talking to, and in talking with his mother, who's present here in the courtroom today, I've come to a conclusion that we're dealing with immaturity, mental health issues, and as well as a substance abuse issue, which I think may very well be a self-medication issue. In speaking with the probation officers in the last 2 hearings, I do believe that NeoCap would be a very appropriate sanction, provided they address both the the issue of alcohol and or substance abuse and mental health at the same time, which they are very capable of doing. It's my understanding, speaking to the probation officer, that NeoCap has accepted the defendant. I believe that this is a very appropriate punitive sanction for the conduct that he is engaged in. And he knows that there will be no more favors done him if he violates yet again. And for those reasons, Your Honor, I would request this court impose a punitive sanction of NeoCap and extend his probation accordingly.
Thank you.
Thank you.
Mr. Reynolds, you have the right to address the court before you are sentenced. You can say anything you want. Is there anything you want to say at this time?
Yes, Your Honor. I'd like to say that, I mean, it took a while for me to see it. My first time in this court hearing, you were telling me about the marijuana. I was telling you I didn't have a problem. And I realized that, like, I need help, not just drug-wise, but I need help mental-wise. Like, I don't know. When life gets scary and gets hard, I tend to just run.
You tend to what?
Just run from my problems, and I need help trying to fight them. And that's it.
Thank you. Mr. Douglas, anything else you want the court to consider?
Nothing at this time, Your Honor.
This court has considered the pre-sentence report investigation that was originally prepared. I've reviewed that again. I've considered the facts and circumstances of the original offenses that brought us here, the nature of those offenses, as well as the defendant's performance on probation and the nature of the violations. I've considered what's been said here today. All of this is considered by the court in light of purposes and principles of felony sentencing set forth in 2929 11 of the revised code. As for the factors in 2929-12, I'm going to incorporate all the findings I made at the time of the original sentencing regarding the seriousness factors and the recidivism factors, with the additional finding here today that the defendant has failed to comply with the previously imposed sanctions ordered by this court, which is a factor indicating recidivism is more likely. It appears, Mr. Reynolds, that for a little bit of time you were doing all right. Not more than a little bit of time. That first year you were doing all right. And something happened come September. I don't know what. But because that you were doing all right, the probation department gave you a chance. They didn't violate you right away. They put you on that review board contract, which if you would have succeeded in that, it would have not resulted in an additional violation. But continued to use, and then you made the fatal error in just disappearing. And you were gone. But I will give you one other chance here with this program at NeoCap, and hopefully that'll give you the resources that you need and the help you need. But this is not going to happen again. I'm not going to have, quite frankly, I'm not going to have anything else to offer you if we come back here. And if we do come back here, then it's going to show that you really aren't sincere. You're just saying what you need to say to avoid prison. But I'll give you this chance. I'll find that you're amenable to an available community control sanction. extend your community control sanctions by 12 months. I'm going to order that you serve 49 days in jail. You have credit for 19 you've already served. However, I'm also going to order that you enter and successfully complete the program at NeoCap, and I'll permit you to be released from the jail as soon as the bed's available. Last week we received some emails saying the wait for men is down to about 2 weeks. I mean, I don't know exactly how long it's going to take. 30 days should be more than enough of a cushion. But as soon as the bed's available, you can be released from the jail. Any balance of that 30 days will be vacated. You're to enter NeoCap in their dual diagnosis program and successfully complete that program. Follow all their aftercare recommendations. I'm going to order at this point, and you very well aren't going to have to do this, but I put it in place in all NeoCap orders, that after you finish NeoCap, you're going to return to the jail for 30 days in the Transitional Day Reporting Program. That's a program that helps people make the transition from being locked up to being on your own. Some people, when they get done serving time, have nowhere to go. They don't have any housing, they don't have work lined up. They just open the gates and say you're free to go, and they don't have anywhere to go. And this is a program that you're in jail, but then you're released during the day to find housing, find work, get all that taken care of. Now, when you're done with NeoCap, if you have housing lined up, if you have work lined up, and you don't need assistance in that, I'll vacate those 30 days. You won't have to do it. But it's a good program for people that do need that help, and I put it in place for everybody in case you find yourself in that position. That's something you can work on while you're at NeoCap to get all that lined up as well, so that you're ready to go once it's over with. You understand that?
Yes, Your Honor.
So at this point, it's going to be part of the order. The other conditions are then going to be the same as what you had. You need to follow the aftercare recommendations from NeoCap, but no drugs or alcohol, including no marijuana. You submit your random urine screens when requested. They have to be negative. 3 AA meetings a week, sponsor. Were you working?
Yes, sir.
What were you doing?
I was working factories at Zerko in Jefferson.
Where's that?
In Jefferson, Ohio. Like right there by ATEC.
I'm not that familiar with that out there. I know where the courthouse is, that's about it. Okay. All right, but anyway, obtain and maintain employment or education, as I said also. If you wanted to further your education or get some type of training, you can do that too, but a full-time basis, you're working or going to school. You have one doctor and one dentist that could prescribe you medication. If you have any specialists, that's fine too, but probation needs to know who they are. So then those are the only doctors you can get prescriptions from. One pharmacy where you get prescriptions filled, they need to know where that is. Continue with any mental health, counseling and treatment, follow their recommendations. Take all medications, if any, as prescribed. Pay court costs and supervision fees. So basically ordering NeoCap, once you finish that, it's back to how it was. You have to, more time to do, but quite frankly, the last 5 months you haven't even been on probation, so that's not going to get credit for that, really. And it needs to be extended, so make sure you complete NeoCap, and you're doing all right. Jennifer, is there anything else I should be considering here?
No, thank you, Your Honor.
So, Mr. Reynolds, you understand all the conditions of your continued community control sanctions?
Yes, Your Honor.
Any questions for me?
No, sir, Your Honor.
All right, I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from this court, or if you were to commit another offense while on probation, another motion to terminate your community control sanctions would be filed. If it's found that you violated, I could extend your probation up to 5 years. I can impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. And if I did that, it would be 18 months on count 1, an additional 12 months on count 2 consecutive, so 30 months in prison. And that would be consecutive to any other sentence you may be serving at that time for some other case, or that you're being sentenced to if there's some new case. You understand that?
Yes, Your Honor.
All right. Mr. Douglas, is there anything else you care to address?
Nothing further, Your Honor.
All right. Good luck.
Thank you, Judge.
We are here in the case of State of Ohio versus Alvin Bridges, case number 24CR1204. Defendant is present, represented by defense counsel Chad Mulkey. Previous date in this court, the defendant pled guilty to having weapons under disability and tampering with evidence, both felonies of the 3rd degree, failure to comply, misdemeanor of the 1st degree, and 2 counts of endangering children, misdemeanors of the first degree. We are here today for the sentencing in the case.
Mulkey, any reason not to go forward with sentencing?
No, Your Honor.
Anything you'd like to say on behalf of your client?
Yes, Your Honor, thank you. And, Your Honor, my client's sister, Shanice, is here and would like to address the court with a few remarks when appropriate.
You can hear from her now.
Very good.
And you can just stand right where it is that you're seated, state your full name and spell your last name for the court reporter here, then take your time and say whatever you'd like me to know.
Hi, my name is Chinese Blair.
Keep your voice up, okay? That's all right.
My name is Chinese Blair.
Can you spell your first name too?
Oh, yes, CHANEICE, last name BLAIR.
Thank you. Go ahead.
I'm the oldest out of 4 with my mom. Basically helped raise them. He has been residing with me for the last, I want to say, 1.5 years now. It was my car that he was driving that day, and I know it was a little bit noisy. We've been working together to try to get his license and stuff together, different warrants and stuff. We've been trying to pay tickets and stuff on. We just recently just started buying it back together so he can get on track with everything. So that's another reason why he's been staying with me. And he's a hard worker. And I just hope that the court knows he's also a good father as well. That's all I would like to say.
Thank you. Mulkey?
Thank you, Your Honor. May it please the court, counsel, others here today. My client is 30 years old. He has 2 children, ages 8 and 6. On the date of this incident, he was planning on taking them to the movies. I believe that when he addresses the court, he's going to indicate that he was nervous about the entire encounter. He had his kids in the car and then noticed that the gun was in there. Your Honor, he relayed to me that he didn't know it was in there at the time he borrowed the car. I believe it was from his sister. You know, he made a very poor decision, and his record would indicate that he's done this before, and even had a case pending while this happened. He's never been to prison before, though, and so I think the consequences of what has occurred here is sitting with him. He's had nothing but time to think about these cases. He knows he's facing a lifetime driver's license suspension as well, Your Honor. So he does care about his children. He's gainfully employed. He currently works at Little Caesars Pizza. He has some college education, Your Honor. So I believe he's going to address the court and say a few things that are on his mind regarding this incident. This wasn't a drug or alcohol related incident, so there's not an issue there, just poor decision making on his part, and given the right tools, meaning maybe some classes, perhaps some decision point, Your Honor, would ask the court to consider not sending him to prison, to the very least some local incarceration, Your Honor, so he has some additional time to reflect and understand that there are consequences for these actions. and that punishment as well as rehabilitation is taken into consideration when the court imposes its sentence. Your Honor, again, he's maintained his contact with my office. He knew he was looking at prison time today and jail time. He showed up, Your Honor, prepared to face those consequences. Thank you.
Thank you. Mr. Bridges, you have the right to address the court before you are sentenced. You can say anything you like. Is there anything you want to say?
I need to stand up.
You can do whatever you're comfortable doing.
Oh man. But then again, I would say I do apologize for basically all this. Actually, even though I did not know, what was in the car, I still take accountability for the actions I still did. Still drove away, still did something I shouldn't have done, and I take full accountability of that. But hopefully, I was explaining on paper that hopefully I get another chance to show y'all that I'm not a bad guy, because I'm not. I work every day, provide for my kids. I don't get in trouble. Only time I really got in trouble is my past stuff, but stuff I didn't really know at the time, like the laws, and other than that, it's just traffic court that I've been trying to fix from 2016 to 17, and I got somebody to help me to get me on board. As to live with my sister, that was the plan, to get myself on board, to be able to get my everything fixed and get on track. But like I said, I'm not a bad guy, but I still take accountability for my actions I did, because I know they shouldn't have did it regardless of me being nervous or not. But I just hope everything go good, but still.
Thank you. Mr. Mulkey, anything else?
Nothing on behalf of the defendant, Your Honor. Thank you.
1 second, Mr. Lewis. And Ms. Gresky for the state.
Thank you, Your Honor. State's recommendation is prison. The defendant's inability to comport with the laws or refusal to comport with the laws, and especially when it comes to these traffic stops, it's the main reason that the state is making this recommendation. The defendant does have criminal history, and I'd like to note in detail some of the conduct that was behind the misdemeanors from earlier this year in Menor, or last year, in fact, December of 2023, the defendant was pulled over in a traffic stop, gave a fake name, a fake date, a fake social, and drove away, sped off and got away from the police. And then a few weeks later in January, Menor pulled him over again, and he gave a fake name and a fake social, and then he did not flee in that incident. However, he did have a falsification conviction out of that incident. From the December 2023 conviction, he had a failure to comply, which is why, with this failure to comply conviction, the driver's license must be suspended for life. Then in August, there's a pending case where the defendant, again, gave a fake name, a fake social, had a child in the vehicle at that point, and sped off, fled from police. And then in this incident, as the court is well aware, the defendant gives a fake name, same fake name as he did in August, fake social. And there's some statements by the defendant as to whether he gave his ID. In the pre-sentence report, he made some statement along the lines that he gave his ID. There were also statements at the scene about that he was getting his wallet to get his ID, but he gave a fake name. He didn't give his driver's license, and he didn't give his ID. So that's not what led him to the center council. In fact, he made multiple statements that he knew that the gun was there. And as to whether he was moving the children for their safety, which is another statement that he made. I have State's Exhibit 1, which I have queued up in the computer to play, and I have it queued to play after the defendant has given a fake name, fake social. The officer's gone to his vehicle, and the defendant has pulled off and then stopped. Now the officer's pulling up to him again. If the court wants me
the
to...
second time he pulled off?
Yes.
Okay.
If the court wants me to play any of it before, I can back it up. But from there, I want the court to see what in fact happened, and that the efforts to evade the police and conceal evidence from the police escalated from all of his priors, both convictions and prior behavior and the pending conduct, to this. And it endangered the lives of his children, 2 children, and was, again, not just to get away from the traffic stop, but also to conceal evidence. So I will just walk over to the computer and play it.
For the record, this will be what, State's Exhibit 1?
Yes.
Sorry?
Unmute the screen.
This is a body cam, correct?
Just before Richmond.
Okay, nothing just before 44.
Just before Richmond Street.
And the second time he pulled off.
Do something just before Richmond.
Driver, get out of the car! Get out of the car! Driver, put your hands out of the window! Get out! Get out of the car! Put your hands out of the window! Get your hands out of the window! Get out of the car! Get out of the car! Come on out! Come back to me! Come back to me! No, come back to me! Come back to me! Come here! Come back to me! Come on! Let's go! Come on! No! No! Come back to me! Come back to me now! Come back to me! Come back to me! Get back! Come back here! We'll deal with that later. Come on! Come back to me! Attitude Central.
Attitude.
Driver's out of the car, refusing to come back to me. Hey, come back here! Come here!
Just hold tight. Roll 2 and 44.
Come back to me! What did you put in your waistband? What is that? Come here. Now. I'm telling you, come here. Come here. With your hands up. Come up. Come back here. With your hands up. You too. You too. Hands up. Hands up. Come back here. Put your hands up. Put your hands up. Attitude Central.
Attitude.
There's also 2 kids in the car. He's got them out. Looks like he's shielding himself with them. He put something in his waistband.
Units not involved, Tech 1. Units not involved, Tech 1.
What are you doing? What are you doing?
Where's this at?
He's headed north, off the roadway. He's running away from me with the kids.
Running northbound off the road, move the kids 2 westbound just before Richmond Street. Let's stop. 41's on the air, up in the area.
Hey!
15 Central, can you let City Nelson that he ran north from the guardrail? Can you show myself and
Hey!
all the
Show me your hands! Don't fucking fucking move.
No.
Don't fucking move.
No.
What is in your waistband?
Nothing, sir.
Hands up right now.
No.
Right now.
I'm sorry.
Come here.
Nothing, sir.
Come here, sir. Come here. What are you grabbing for?
I got my phone, sir. I got my phone.
Okay.
I got my phone.
Turn around for me.
Can I call my sister, please? I just want to call my sister.
Not right now. Why didn't you stop for me? Why did you run away from the stop?
I'm just nervous, sir.
Why are you nervous?
Stop.
We're gonna stay here forever.
Stop. No, we're not.
Daddy,
No, we're not.
we're going to jail.
And 2 Central.
Adam 2.
Come on, y'all.
I got the mail and
Come on.
Pepsi. Kids are following us back up to the highway through the woods.
Copy mail.
Come on,
Copy.
kiddos.
Call back up to the highway. Radio's yours. If you got anything, just go ahead and talk. Don't worry about handling me.
Come. Yeah, they're back here.
That's on the highway.
Come on up, kids.
They're down below. We're almost back up to the freeway.
Yeah, there's 2 kids.
Yeah.
Come here, guys. You okay? Why did you do that? What's wrong with you?
I'm just really nervous, sir.
Why are you nervous?
I'm sorry.
You put yourself in a bad position, put those kids in a
I'm
bad
really
position.
sorry. I'm really sorry.
Come on, step over here for me. What is your social? Give me your own social.
Go ahead. Keep the speed going here. Disregard the wall.
7027.
Disregard them. Thank you.
What did you put in your waistband? Did you drop it?
I promise I didn't.
I saw something in your waistband.
I
What was
promise.
in your waistband?
Dude, here's the thing. We found that if you left the gun back inside the home, someone's little kid shoots themselves in an accident because they found the gun. Think about this.
I'm trying to tell you, sir. I'm trying to tell you, sir.
I saw you put something in your waistband. Gun inside themselves. Someone finds it, shoots themselves, and kills themselves. You have to live with that for the rest of your life. Understand?
Yes, sir.
Man to man.
Yes, sir.
Let's own a simple gun charge. Where'd you throw it?
I'm trying to tell you. I grabbed my wallet. My wallet is black. I grabbed my wallet.
Where's your
Why did you put your wallet in your waistband?
Well, I dropped my wallet.
Okay, why did you put your wallet in your waistband?
Sir.
Why'd you run?
I
Your kids are shit.
I didn't try to do that. I was looking at the panda, right? My kids are saying am I able to call my sister?
No, not right now, buddy. I gotta figure out who you are first.
Okay.
And then, we gotta do something with the kids. All right?
I got a sister that's like 10 minutes away.
My notebook's in the car. Can you hold him for a second?
What's your first name? A-L-E-V-E-I-N. And what's your last name?
Bridges, B-R-I-D-G-E-S.
I ain't Jermaine Wainwright, bro.
Yes, sir.
What's your date of birth?
06/26/1994.
06.
26?
1994.
You have a middle name?
No, sir.
You have a middle name?
What's your social?
296-96-7027.
29696.
7027.
Buddy, this could have been a lot easier if you just told me who you are.
Go ahead.
I really apologize.
Warrants?
I probably do. That's what probably.
296-967-027.
It's really just, I was just trying to take him to the movies.
Buddy, you scared the shit out of me. Not gonna lie.
I'm really sorry. I'm not even a bad guy.
Okay. So we're gonna deal with it now. What's your sister's name?
Shanice Blair.
Denise Blair?
Yes.
Who you calling? For the kids.
Yeah.
Sister or baby mama? Where's baby mama at?
Baby mama is in Youngstown.
Youngstown?
Yes.
That's your
But
father's sister.
my sister literally, she stays on, I don't know the exact code, but it's South Ridge Road. It's probably not even like 10 minutes away from here.
I'm assuming you have your own charges, though.
We do.
Did all that for a misdemeanor warrant that might not
I mean, Elvin Bridges, valid ID card only.
I was just really
No
sorry.
license that can be confiscated on behalf of the registrar.
We searched it.
I'm sorry.
Sergeant Sushek had asked him all of this for a misdemeanor warrant, and he said yes. She was very nervous. And I'd also like the court to know that, as officers came to speak with the boys, they were crying, they were upset, as can be seen partially in the video, but they were also asking officers if they were going to jail and if they were going to have to be there. Then in the second clip, because there has been, again, in the pre-sentence report, some discussion about what, if any, knowledge the defendant had, his own questioning of it. He makes some statements in the second clip. Portions are muted, so I will fast forward those.
Everybody got to read you something, okay? Yes, sir. I'm a police officer. More than anything you say will be used in a court of law against you. You have the absolute right to remain silent. You have the right to advice of a lawyer before and the presence of a lawyer here with you during questioning. If you cannot afford a lawyer, one will be furnished for you free before any questioning if you desire. You can stop answering questions at any time. You understand that? Yes, sir. Okay, you don't have to talk to me if you don't want to. I'm going to ask you some questions, man, because I'm trying to figure out your mindset and what you do. Okay. So, you stopped. You initially stopped. You didn't give me your name. I get you got warrants. You're probably nervous about the warrants, right? Yes. Okay, we got a gun. We got the gun out there. So, bro, that's you were really close, man. It scared the shit out of me. You understand? Yeah. I've never had anybody run in the woods with a gun. I knew you had a gun. Okay. So you gotta be honest. What'd you?
So basically, I can explain. So basically, the gun. I came from Youngstown. My girl stayed. My baby mother stayed in Youngstown. The gun was registered to her. So she was in the car, while we ran some couple errands. And when I basically knew, I was like, well, I'm getting pulled over. I got nervous. That's my nervous.
You got the gun in the car. That you the gun was in the car.
I don't supposed to have. I'm already got.
You seem like a straight up pro.
I am. I work.
Well, you cool?
I got nervous.
I appreciate you not shooting me.
I'm not gonna do that.
I appreciate that.
Yeah, I'm not.
I don't want to get shot. You know what I'm saying?
Nobody wants to get shot. So I just.
So you knew the gun was in the car. But you were just nervous, and that's why you decided to get out.
And then I thought I'm like,
bro, you were running away from me mid traffic stop with those kids in the car. You know what I'm saying? That's dangerous, dude.
Yes, sir.
Real dangerous.
Very
okay, and then you stopped. Thank God you stopped, and you got out. You grabbed your kids, put them in front of you. What do you think you were doing with that? You grabbed the gun, put your kids in front of you. What do you think that was gonna do?
Well, I didn't.
That made me like, oh shit, this guy's gonna shoot me.
No, I didn't. No,
you know what I'm saying?
I'm not even that type of guy.
No,
Yes, I do.
What do you do?
I work at a place called Cash Nylons, and I run a business with my dad.
Okay, all right. And that gun's not yours, but you knew it was in the car?
I know.
Where was it at? Do you remember?
Yes, it was in the glove.
It was in the glove box? The glove compartment?
I don't know if that's not, I would say the...
Oh, the center console thing? Was it in between the seat, or?
No, in the center console.
It was in the center console, like you had to lift it up and grab it?
Gun?
Yes.
Yeah, that's where it was.
Okay.
It's open. You can tell that's where the gun was.
Yeah, so basically, when I figured out, I'm like, I just panicked, because...
Yeah.
I wouldn't...
Scared the shit out of me.
Wouldn't even have that with me.
You're not allowed to have a gun?
I don't know. I just explained to him how the gun even got there. And it's Magnum mine.
She knew it was in there.
As I say, after the fact, like, yeah. Because when I ended up pulling my wallet out.
Oh, okay. Before you said you knew your sister had left it in the car, but now you're telling me that when you got your wallet out, you saw it.
But I'm telling you that's.
Your wallet was sitting up there, so there's no reason for you to pull the.
No, I pulled the wallet out.
Wait, your wallet was.
No, I figured you was going.
Oh, okay. So you knew there was a gun in the car. You didn't tell me though when I was on the stop.
That's because I just got nervous.
Okay, but you knew that you had the car. All right, buddy. Appreciate you.
Go ahead, Ms. Gretzky.
There's nothing further, Your Honor. That's
Anything
all.
else you want us?
I've covered everything.
Okay.
Yeah, and the pre-sentence report outlines all of the outstanding warrants, so I have nothing further. Thank you.
This court reviewed the pre-sentence report and investigation, considered the facts and circumstances of the offenses involved, the nature of the offenses involved. considered State's Exhibit 1, which was played here in court. Considered what's been said here in court by the defendant, his lawyer, the prosecutor, defendant's sister. All this is considered by the court in light of the purposes and principles of felony sentencing set forth in 29-29-11. So the factors in 29-29-12, factors indicating the conduct is more or less serious. The court notes that there were 2 minor children in the vehicle at the time this occurred, that the defendant used as human shields when he got out of the car. He completely disobeyed the police officer's commands, put himself at risk. The 2 children, you're so lucky you weren't shot, and the children weren't shot. An officer knowing you had a gun on your hip and then you putting them in front of you and you going into the car when he's telling you to come to him, he had every right to do that. But these children being in the car and used in the manner that they were used makes this not more serious, I mean, most serious that I've dealt with. Tampering with evidence is more serious too. You have a loaded firearm that you just leave in the roadway, and the officer's telling you there's could be kids that come and find this, and you still say, "Oh, it's just my wallet. I left my wallet." Nothing makes it less serious than any of the offenses. As for recidivism factors, the court notes the defendant does have a history of criminal convictions. And the worst part of it is this is the same type of behavior. In Menor, about 8 months earlier, you're convicted of failure to comply, and engage in the same type of conduct. You didn't get stopped in Richmond Heights. Those charges are pending. Almost identical behavior with child endangering, where you stopped and you left and you fled and you get stopped again, you have a kid in the car. To say that you don't get in trouble and you don't do this, there's a prior conviction, there's a case pending involving identical behavior, then you have this. All within a few months of each other. You blamed the fact that your girlfriend or the mother of your kids left you in September. That doesn't explain the Richmond Heights stuff that happened in August. Doesn't explain this offense either, quite frankly. To put your kids, to make them go through what they went through there. And aside from this stuff, then there's other convictions. You have a weapons charge in 2017. Attempted receiving stolen property. Before that, you were on probation to Menor Municipal Court when you did this offense. And you do the same thing. And aside from that, that's traffic. You got 14 prior convictions for driving under suspension. So suspensions mean nothing. We have to give a lifetime suspension. But that doesn't mean anything. You'll be out driving as soon as you can, apparently, because that's what you do. You have 5 warrants out for you right now for failing to appear for court hearings. I mean, there's just zero responsibility. Failed to comply with previously imposed sanctions ordered by courts. That's a factor indicating recidivism is more likely. There's not genuine remorse. You're trying to come up with some innocent explanation for this. Or just, I missed my kids. I wanted them to take them to the movies. again, you've done it before. Same thing. And your explanations and lies to the police, that's not genuine remorse. Nothing indicates recidivism is less likely. These are felonies of the third degree, which carry no presumptions one way or the other. Prison is consistent with the purposes and principles of sentencing, and it's deserving in this case. No question about it with the conduct that was involved and the risk you put police officers at, put your children at. My God. Therefore, sentence this court on counts 3 and 7, defendant serve a term in prison of 24 months on each count, 180 days in jail on counts 5, 9, and 10. Those will run concurrent for 24 months in prison. He has 12 days of credit. Further, permanently revoked the defendant's driver's license on count 5, or the defendant pay all costs. Need to advise you upon your release from prison. You could be placed on post-release control for up to 2 years. If you are and you're violating the conditions of your post-release control, the parole authority can send you back to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50%. Or half of the prison term imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. The remaining counts of the indictment are dismissed. Is there anything else for the record or anything omitted?
I apologize if I
I'll
missed
release
it.
bond also. But
Was there a sentence on counts 9 and 10?
I think I said 180 days in counts 5, 9, and 10.
Okay, I'm sorry, I missed that.
And everything's the run concurrent.
Thank you.
Mr. Mulkey, anything else?
Nothing on behalf of my client, Your Honor. Thank you.
All rise.
Honor, we're here this afternoon in the state of Ohio versus Ramel Peters, case number 25CR152. The defendant is present in open court with his attorney, Mr. Clammer. We were last before you on February 24th. At that time, the defendant did enter a plea of guilty by way of information to count 1, possession of cocaine, a felony of the 5th degree, count 2, possession of heroin, a felony of the 4th degree, count 3, possession of cocaine, a felony of the 5th degree, and counts 4, 5, and 6, all trafficking in cocaine felonies of the 5th degree. Your Honor ordered a pre-sentence report and a drug and alcohol evaluation. Both have been completed. We are here for the purposes of sentencing, and the defendant has 1 day of jail time credit.
Thank you. Mr. Clammer, any reason not to go forward with sentencing?
We're prepared, Your Honor.
Anything you care to say on behalf of your client? I did receive the sentencing memorandum and thoroughly read that, but obviously if you address the court.
Yeah, thank you, Judge. Judge, thank you for, I know a lot of it's in the sentencing memorandum, and I know we talked in chambers.
You can still say whatever you'd like to say.
Yeah, let me reiterate. So, you know, my thinking on this case is that I think it's an incredibly unique case, and then obviously those are the facts that I think are in Dr. A's report, and most importantly, the facts that you know now just about Ramel's history. The reason I think that's important to judge is I know my ask in this case is incredibly outside the spectrum of what you might see for an F3 drug offender. What I'm going to ask you to consider is, in hearing again my reasoning for it, is I think that you have a wonderful opportunity to include some of these factors in your sentencing entry. I would imagine, having never sat on the bench, that every judge has some concern if they're going to go outside the spectrum of how that manipulates a little bit the similar sentences analysis. So us defense lawyers will go look for prior sentences. If you give Mr. Peters a break, somebody else is going to pull the Mr. Peters case. The problem is when we do that, we never know what the facts are of the case, right? We just kind of get the routine sentencing entries, and there's nothing in there to really give us a perspective on whether the facts of the case or the facts of the offender were similar. So I could sense that for any judge that creates a little bit of an uneasiness if we're going to try to do anything creative, not to say that you're not creative, but I think you have an opportunity here to draft a sentencing entry if you were to go along with what we're going to propose, where you can detail the facts of that sentencing entry to say this case is out of the norm because of all these different things, as opposed to our more kind of traditional sentencing entry we see that doesn't touch on those things. We know you're going to make the findings, but I think in addition to those findings, you have a wonderful opportunity to explain to obviously Mr. Peters, to a court of appeals, and to anybody else in the public or other defense attorneys who might look at cases of why Mr. Peters' case was incredibly different and why we think it's deserving of a rather unique sentence. But you did hear, he was ultimately, I think every judge, the issue is how do I make sure that this doesn't happen again, because I got to keep the community I serve and the community I live in safe. You should already have some comfort that all of that was perfect for Ramel for 40 years of his life. I think he's 40 now. 40. So literally crime-free. He's got a bit of a traffic history, but he's taken care of all of that. He was charged with an OVI at some point in time, but he was acquitted. So first offender by any definition. So that should, I think, give you a first sense that if there's somebody that's entitled to a break and he's not going to make the community more dangerous or make any one of us in this room or the system look foolish, it's Ramel. You already have that history. And we also know along the way, not only did he graduate with a 3.8, he went off to Youngstown State. The way he describes it to me is that he entered into some kind of early admission into the banking system with Chase, and he ultimately gets accepted early, and so he ends up leaving Youngstown to go working in the banking industry. He's doing that for a few years. I think he may have gone to a couple different banks.
Yeah.
And then he's always had this entrepreneurial desire, so he and some friends started their first business. I think one of the first ones was a car wash, and you will have heard the name Marvin, his best friend, in the briefing, who sadly passed. But that was his best friend in his first business. He ends up finding his way down here, and how he winds up doing trucking logistics. He now owns his own trucking logistics business, which you can imagine. He's got a number of different trucks. I think they travel around the country,
yes, sir.
Doing deliveries. He manages all the employees, and whether they're 1099, but he manages all of the logistics related to that, the customer service and everything. And by all accounts, man, he was, and I like to say is and will be, again, super successful. He was very proud of I mentioned this a little bit in chambers, Judge, but I think it deserves to be on the record. We talked, and the record should reflect, obviously Romel's a black guy, but we talked a little bit about the disappointment he had in himself that in some communities people might assume that a black guy is going to commit an offense. And he had been not that person for so long, and his heartache for himself that he kind of, in a sense, became a cliche in that regard. I hope you don't mind me saying that to you, but he was heartbroken, and the only family member, save his mom, who's living in Columbus, is his uncle, who spent his whole life in law enforcement, is still in law enforcement to a certain degree. He's got to look his uncle in the eyes too, and in a sense be that disappointing cliche, and I know that's heartbreaking to him. And the reason I mention that again is not for sympathy, Judge. It's just another bit of evidence or another factor to give you some comfort that this is different than any other case, and this isn't going to happen again. But then we're left asking ourselves, why did this happen again? And I never try to say that tragedy excuses behavior, because it's hard to link depression to bad thinking. You know, it's hard to link PTSD to criminality. It's hard to do those things because I think it is so complex. But the only factors we have that even begin to touch on who was Romel before and who was Romel that committed these offenses are what I call the avalanche of loss that he suffered from 2019 through 2023. And there was one more that I forgot to even put in the brief. So you had heard, he would tell you his father was his closest friend. His uncle may even touch on that as well. I discussed him taking his father for a minor treatment, and because his father was diabetic, he ended up having to make a determination to remove his father's fingers and toes. Ultimately, they moved to another place, and he was with his father throughout that. And they started a conversation, and his father was intubated, and it was a conversation where they communicated by blinks. And at one point in time, the question to his father was, "Dad, do you want to be here anymore?" And his dad blinked two for no, and he said, "Dad, do you want me to take care of Mom?" And that was always the warning that he had given his son was, if something happens to me, you got to take care of Mom, because I think she's a little younger than he was. And he blinked twice to his son as his son was holding his fingerless palm, for lack of to be gross, Judge. But it was, my point being is, it wasn't just a loss. That was a tragedy that he suffered intimately. He would then lose, you may have seen it in Dr. Sarifar's brief, he would then lose his adopted sister, Juanita, who was killed by her brother sometime in 2020. So his dad dies in 2019. His brother dies, or his sister-in-law is killed in 2020. And then from there, Judge, the avalanche continues. You know that he lost Marvin, who was his best friend, who was in a car accident. He drove down there to see Marvin. Marvin's in the hospital. Marvin gives him a thumbs up, like everything's going to be okay. He had a neck brace on, back brace on. I think he was talking to either Marvin's fiance or his wife at the time. Everything's going to be okay, and I think before he even made it home from Columbus, he gets the call from Marvin's wife or fiance that Marvin suddenly passed, which seemed to have been unexpected to everybody. Shortly thereafter, I think we lose Donnie, his brother, who was in a car accident, walking down the side of the road, and again, Romel's called to his bedside to figure out what we should do, and the way he describes it is everybody turned to him to decide should they pull the plug on his brother Donnie, and they harvested some organs, and then they pulled the plug. And within 4 months, I think July of 2023 is when he lost his other brother, Darrell, who we think now had been hiding his cancer for a considerable period of time. And then ultimately, he too passed unexpectedly. The way I phrased the brief, that Romel never likes to end a telephone call with "I'll call you back later," because Darrell had called him, or whoever's at his bedside called him to talk to him, and he was in the middle of something else, and he said, "I'll call you back later." And the next thing he heard was his brother had passed away. So the only evidence we have of what would have struck or caused Mr. Peters to deteriorate is that avalanche of loss that I think is unlike, Judge, any other case you would have, and I think justifies a huge deviation. I think ultimately you could sense from my brief, with the fear of sounding like a progressive, like I surely am, I think the community, through this system, Judge, and with you deciding what's best, has an opportunity to make this system work to care for somebody who desperately needs it. Every crime obviously has a victim, but in a sense this is a victimless crime. We believe that the confidential informant in this case who was working those buys was somebody who was participating in this behavior with Rommel beforehand. So I only say that to say the definition of victim, I guess, would be really loose in this case. But ultimately, I think the focus here needs to be with Rommel. I don't think, and some of these things happen for a reason, and I'm sure I don't want Rommel to have to suffer a real serious penalty to have recovered, but I think this did happen for a reason, and I think we have a wonderful opportunity to help him get through his distress. I've been with him for a while, and I see when his thinking gets confusing, he can go from on top of the world with being super successful with his business to, I think my world's over. And on that night when they searched his house, or that day when they searched his house, he was at that point that his world was over because of what he had done, and he was the one that disclosed the whereabouts of the cocaine to the officers. They likely would have never found it. Judge, further, all those things aside, if you look at all the seriousness and recidivism factors, I think they all speak to this being less serious than any other offense, and most importantly, I think with every case, Judge, especially in one like this where the victim, I think we would have to use a very broad definition of victim. I think you would look to the non-likely to reoffend factors, and I think, A, we already know his history, that he can prove that he can make it 40 years without ever offending, and I think I have 5 of them in my mind that are all marked off as factors suggesting not likely to reoffend. Trying to understand then, Doctor, why Rommel would have behaved the way he did, I think you can look at Dr. Afsarifar's report. And the report has much more in it than I noted, but you see this excessive worriness, the compulsivity, the thought dysfunction that he's seeing, and the sad part to me is the doctor indicated elevated findings in suicidal and death ideation. So there was a point in time that from time to time Rommel would be suicidal, but the way the doctor, it may not be in the report, but the way I think he describes it is he just became, he's at this point had become, in a sense, obsessive with thoughts about death, and I have to assume that that in large part was what he went through in that 4-year period, losing all those loved ones close to him. The Rorschach test, Judge, also showed not only the depression at a critical level, but most importantly to, I think, trying to understand why Rommel behaved the way he did. It noted the coping deficit, meaning, obviously, I think we all know what a coping deficit is, but an inability to cope with all the grief that he had. So what I tried to propose to you, Judge, is I like to think something creative, and it is reaching out beyond what we normally have, but I think it's consistent with what you might do in drug-offended people, where you order daily AA meetings or really intensive process to deal with those abuses. I think we have a variety of grief and mentoring and men's programs in Lake County. I don't know that you typically order people to participate in them, but I don't think Rommel's suffering is typical. So I did propose ordering him to go through the NAMI mentoring program and the men's group, which meets weekly. I think both of them meet weekly. And through NAMI, I was able to identify a couple local churches, one in Mentor and one in Painesville, that have weekly grief support groups. I think, putting any drug addiction aside, I think ordering those as kind of an intensive AA type program for people with very real grief, I think those are the appropriate tools, and certainly going to force him to take care of himself. And I do think, Judge, wherever he's going to go, he's going to also wind up a mentor for people suffering as well, because I think he's that kind of person. But ultimately, Judge, I'd ask you to, I think we tried to find some similar sentences. It's not easy to do, of course, but I did show you a few that, obviously it was an F3 possession of marijuana, but it was an F3. So there are sentences for people with F3s, F4s, and F5s with drug-related possession cases. Now, I know he has the trafficking, but my focus, of course, is the F3 at this point, where we're seeing people with 90 days with work release, 30 days with work release, 5 days. I don't know the facts of those cases, but I'll never know the facts of those cases, but I can almost guarantee them, in none of them did they have the history of lack of criminality like Rommel, the history of tragic losses of 5 loved ones in a matter of 5 years. The evidence that he's managed to succeed since the offenses, his drug screens were clean. I just think he's a wonderful person. Like I said, I think he succeeded before, and he's going to succeed after all this stuff. But ultimately, Judge, I am asking you not to incarcerate him. I don't think it's necessary at this point in time. I think he'll understand the point and the gift if you don't do that, and he'll know the consequences if he does violate your orders and doesn't find a way to recover. I think you can fashion a sentence and outline the factors in your judgment entry, to make it very clear that anybody would see why you deviated from what it might be, dare I say, more typical. So I think you have those tools. And I know that NAMI and the churches would probably benefit from having him there as well, as much as him benefited from being there. But I'd ask you to hear from his uncle, who is a former law enforcement, Robert Cross, I think it is, who now works for BMV. I'd ask you to hear from him, and then Ramel. Thank you.
Well, sir, you can stand right where it is that you're seated, or you can stay seated if you want, whatever you're comfortable doing. State your full name, spell your last name, please, and take your time and say whatever you'd like me to know.
First of all, good afternoon, Your Honor.
Good afternoon.
My last name is Gross, C-R-O-S-S. I actually never made mention of a lot of my past, but yes, sir, I retired from law enforcement after serving 33 years. I then went on to work for the state of Ohio for the Bureau of Motor Vehicles and Investigations. I would just like to let you know that Romel has a supportive system in place. I am just going to give you a brief example of the family support that he will have. He has a cousin who was in the war, was in a tank, and the tank was fired upon and people lost their lives. His cousin, who is my son, returned home. And he had issues as a result of what he had experienced. I didn't know how to relate to him. As a result of not knowing how to relate to him, in my 50s, I returned to school and earned several additional degrees, one being a master's degree in social work, because not only did I want to be able to help my son, but I wanted to be able to help other vets as well. And as a result of those type things, I'm just telling you that Romel has a support system that is in place, and I will be there to make sure to assist him in reaching the goals. I really don't want to go into too much other detail, but when I appeared with him several weeks ago, I noticed the plaque there before you. I said that must be important. This must be important to this judge. Let me take the time to read that. I requested, the bailiff actually brought it back to me, and he let me photograph it. I took a photograph of that. I sent it to several family members, and including Romel, and even your plaque has been discussed, because I believe what that says, but at the same time, I also believe in the support system, and I know that a good support system will enable someone who makes the decision and the choice to do things right. It will enable them to reach those goals. Thank you, sir.
Thank you, sir. Mr. Peters, you have the right to address this court before you are sentenced, and you can say anything you'd like. Is there anything you want to say at this time?
Yes, sir. Basically, I just wanted to apologize to the court, my family, of course, myself. I feel like I failed myself more than anything. I never would have imagined being in these shoes 40 years later. 20 years ago when I graduated, I would have thought I'd be a CEO, or I never would have imagined standing here. So I'm highly disappointed in myself, and I'm working hard every day to become a better person.
Thank you, sir. Mr. Clymer, is there anything else you'd like this court to consider?
No, Judge, thank you.
Ms. Contour for the state of Rhode Island.
Thank you, Your Honor. The state is putting forth a recommendation of 48 months in prison. That was the cap that the state capped their recommendation at the time that this agreement was made. And the reason that that has not changed is partly because Mr. Clymer and I had so many conversations about this case before the information was ever filed. And it is true that Mr. Peters was extremely forthcoming with the LCNA officers, and that should not be taken away from him, because when I went to Mr. Colson to talk about this case, that was the primary reason, along with his lack of history, in which we went from an F1, which is what this case would have been with mandatory prison, to the F3, so that Mr. Clymer could make his arguments with regards to community control sanctions. However, the gravity of the situation is that the evidence shows that it wasn't just one sale or one buy or one person that he was selling to. The photos of the home, of what it looked like, it was first 3 buys culminating in the search warrant. And inside of the home, there was the 40 ounces of cocaine, which was in a water bottle in the kitchen with a fake bottom, as well as 2 scales. In the living room, there was a backpack with individually packaged heroin. There was 7 firearms throughout the home, which we've put at least some of those in the forfeiture. There was also $4,000 of cash in his office, and that did include $100 from the LCNA marked bills, from which the sale had been completed, Your Honor. He self-reported that he was using between $500 and $1,000 of cocaine a day. And even at the reported salary that he put in his PSR, there is still a large discrepancy in order to afford that, which I think shows the magnitude of how much cocaine, potentially heroin, he was selling and the gravity of the situation. So the state took all the things that Your Honor is aware of into consideration already. That is why we're here with an F3 rather than the F1. So we did not ignore those things, but this was part of a criminal course of conduct. They are serious charges, and we do feel like prison is appropriate in this case. Thank you.
Thank you. This court has reviewed the pre-sentence report and investigation that was completed. Drug and alcohol evaluation that was completed. I received a sentencing memorandum which had the defense's own assessment and evaluation attached. I've read that as well as the sentencing memorandum itself. I've considered everything said here in open court today by Mr. Clymer, the defendant, Mr. Cross, recommendation from the prosecutor. All of this is considered by this court in light of the purposes and principles of felony sentencing, which are set forth in 2911 of the revised code. For the factors in 2912, indicating the conduct is more or less serious. For count 1, the sheer amount of cocaine involved certainly makes it more serious. Also the presence of, prosecutor said 7 weapons. I counted 6. Maybe I missed one in the version of the PSR, but there was at least 6, if not 7 firearms located at the time. So there's firearms present, which make it more serious. And the description of the house itself, it's a cocaine distribution center. Guns, cocaine, scales. Nothing makes the offense less serious. For factors indicating recidivism is more likely, none of those factors are present. As for factors indicating recidivism is less likely, defendant doesn't have any prior history. No prior juvenile delinquency adjudications when he was a minor. No convictions as an adult, led a law-abiding life for a significant number of years, basically his entire life. I don't want to ignore the tragedies that the defendant has gone through. I don't question them in one bit. I don't see how they lead someone to start being a cocaine dealer in this sense. There's a presumption for prison on count one. I think prison is consistent with the purposes and principles of sentencing. And this type of, this behavior needs to have consequences. It can't be ignored. The circumstances that were put forth here already have been recognized by the state. It's a significant reduction, not only from an F1 to an F3, but no gun specifications, which there could have been. And I'm not saying that was unwarranted, but that's been taken into consideration. The prison is consistent with the purposes and principles of sentencing. The court finds at this time the defendant is not amenable to any available community control sanctions. Therefore, it would be the sentence of this court that on count one, defendant served a term in prison of 36 months. On counts 2, 3, 4, 5, and 6, he served a term of 12 months on each count. I run all the counts concurrent with each other for a 36-month prison term. He has credit for 1 day. I need to advise you upon your release from prison, you may be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the prison term imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. An order of mandatory fine of $5,000 on count one. An order of the forfeiture of the $4,000. I forgot about that when I was going through the description of the place. But $4,000 in U.S. currency that was seized, as well as the guns that are set forth in the forfeiture specification. If there's any other contraband or instrumentalities, those are forfeited. Defense order to pay off costs incurred in this action. Is there anything else that I omitted or need to address?
Not that I see, Your Honor.
Mr. Clammer?
No, Judge.
Your Honor, we would like the court to consider community control sanctions for Mr. Stevens. Ultimately, I know we had long conversations about this case, and I know he informed the court, the PSR, as well as myself, that there was a family emergency going on in this instance. I know this event has brought up a lot of trauma for him in his past, as he witnessed ultimately his best friend came home to him with an overdose. And I know he didn't want that to happen and occur in this situation. I know there's numerous things he could have done, but ultimately he was in that mindset with the past trauma he experienced. He knows he should have stopped at this instance, but that's what was on his mind at the time of this incident, Your Honor. He does have a valid license now. He was able to achieve that during this time period from this incident and up until sentencing here. He is the primary caregiver of 2 children. He also has co-parents another child from a previous relationship, so he does take care of 3 children with that respect. He does work full-time at PCC Airfoils. He's a sandblaster from my understanding. He loves that job. He's been working it for over a year. He values that job very dearly, as it does support him and his family with that respect. He does work from 6 a.m. to 2 p.m. from my understanding. He did graduate from Riverside High School in 2008. He did go to the University of Akron for some period of time, then transferred to Lakeland Community College, Your Honor. So he does have some business credits completed under his belt. With that, Your Honor, we're just asking for any leniency with regarding to this situation. I know he does have 8 days of credit, but we'd like the court to consider community control sanctions at this time.
Thank you. Mr. Stevens, you have the right to address the court before your sentence. You can say anything you like. Is there anything you want to say at this time?
Well, first off, I apologize for even being here with the situation. I should have had better judgment at the time. And second, I just want to thank you for allowing that release, just so I was able to get home to my family and be able to help to take care and get back to work. My work was very lenient with me to get back to work, and they were doing anything that they possibly could to help me out, just because I am a valued employee there. So I do apologize for the situation up front, and I want to thank you for allowing me to have that bond.
Anything else you'd like to say? You don't have to. I just make sure you said everything you want to say.
No, that's all right now.
Mr. Novotny, anything else?
Nothing further.
Ms. Zabreski for the state of Ohio.
The state recommends community control sanctions. This was part of the agreement for the information. Do you know that the defendant violated bond, but considering the other factors present in this case, the state will maintain its recommendation for community control sanctions.
All right, this court did review the pre-sentence report and investigation. Drug and alcohol evaluation, that was completed. I've considered the facts and circumstances of the offense involved, the nature of the offense involved. I've considered everything that's been said here today. And Mr. Stevens, as a lawyer, the prosecutor, the recommendations. All this is considered in light of the purposes and principles of felony sentencing, which are set forth in 2911 of the revised code. As for the factors in 2912, factors that indicate conduct is more or less serious. Well, not a stated factor, but I do find the conduct in this case is less serious than the normal conduct we see in fleeing and eluding charges. The defendant was not driving at a high rate of speed. He actually did slow down to talk to the law enforcement officer to explain his thoughts or position. Now, he didn't stop, and that's why we're here, because he still didn't stop.
is less serious than the normal conduct we see with these offenses, which are taken by this court pretty seriously. I will note, under the seriousness factors, the defendant was under suspension at the time when he committed this offense. So that's a factor indicating it's more serious, but then again, the overall nature of the conduct itself is less serious than the normal conduct we see for these types of charges. As for recidivism factors, the defendant does have a history of criminal convictions. This is his first felony, but there are multiple misdemeanors over the past 10 years, and 6 years before that was a petty theft charge as well. There is a prior probation violation, which would indicate he's failed to comply with the previously imposed sanctions ordered by the courts. He also did test positive, which is a violation of bond, indicating recidivism is more likely. Nothing indicates recidivism is less likely. So we have a valid license now?
Correct.
Because you indicate that, it didn't make much sense to me. You said something to the effect like, I understand I had a suspended license, but I had to do what I had to do to get home. But that doesn't explain why the car was with you to begin with, when at the workplace to be able to drive it to get home. Shouldn't have had a car there that you can drive home, because it means you drove it there, and there was no emergency there. But you've taken care of whatever it was at this point?
Yes.
I'm considering, well, I'm sorry, under 2913 B1. I don't find any factors present. Prison is not consistent with the purposes and principles of sentencing, and the defendant is amenable to an available community control sanctions. So, I'm going to put you on community control sanctions for a period of 2 years. There's going to be consequences, though. Like I said, these are serious offenses, and this isn't as serious as the others. But I'm not going to treat this like I treat others. But I am going to order the defendant to serve 45 days in jail. He has credit for 8 days he served. I will grant him work release privileges. However, you work from 6 to 2 Monday through Friday?
Yeah, I work from 6 to 2, but there's I do overtime as well. So sometimes I work 6 to 4, sometimes 6 to...
I'm going to be able to give you 40 hours of work release with time for travel before and after. You have work release from Monday through Friday, 5:15 a.m. to 3 o'clock p.m. For the rest of the remaining time you have left to serve. Further conditions, you're not to use any drugs or alcohol. You must submit random urine screens. Now I'm going to let you work tomorrow?
Yeah.
All right, I'm going to let you report to the jail tomorrow at 3 o'clock so you can go to work tomorrow. Because otherwise the paperwork won't be done to let you out tomorrow. So it'll be done by tomorrow when you show back up, but it won't be done right now, otherwise they wouldn't let you out tomorrow. So defendants to report tomorrow at 3 p.m. starts the sentence. No drugs or alcohol. Must submit random urine screens. They have to be negative. A positive screen's a violation. No drugs also means no marijuana. It doesn't matter whether you have a medical marijuana card or not. You're not permitted to use any drugs, including any marijuana. You're
to attend 2 AA meetings a week and have a sponsor. I want you to obtain a drug and alcohol evaluation and follow whatever recommendations they may make for any type of treatment. Also, you're to obtain a mental health evaluation, see if they recommend any type of counseling or treatment. You have the issue that you mentioned here involving, is it the friend or the brother? I can't remember off the top of my head.
Roommate.
The roommate. So just a mental health evaluation. If they recommend any counseling, follow those recommendations. If they don't, then there's nothing more you need to do there. Repair court costs and supervision fees. You're gonna complete this decision point program with the probation department. The fact that this was reduced to an attempt means there is no, I don't have to suspend your license, and I won't do that. Ms. Crook, is there anything else I should be thinking about here?
No, Your Honor.
Mr. Stevens, understand all the conditions of your probation?
Yes.
Any questions for me?
So, if I was to do, you know, the time and stuff, how does this work? Because if I'm, like, I don't know how this stuff works, like with work release or
No,
whatever.
there's just separate place in the jail for anyone that has work release, and you'll be released every morning at 5:15, and you need to be back by 3 p.m. Monday through Friday. You drive, so your car will be left out in somewhere in one of the parking lots, and you'll be able to. I'm assuming that's how you're going to go. You don't have to drive. Someone can pick you up and bring you there too. That's up to you to figure that out. It's always a lot for people that have their own license. In a car, that's the easiest way to do it. It's very difficult when people don't, that someone's got to pick them up every morning and drive them there, then drive them back, but you can do it however you want to do it.
Okay.
You have any other questions?
No.
I do need to advise you if you fail to comply with any of these conditions and the rules of probation, if you leave Ohio without permission from the court, or if you commit another offense while on probation, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years. I can impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, it'd be 12 months in prison. So that's what's hanging over your head. Do you understand that?
Yes, I actually do have another question.
Sorry?
So what about weekends, though? Like, do I just have to stay in jail the whole weekend?
Yeah.
Wow. Okay.
Anything else for record, Mr. Gretzky?
No, Your Honor. Thank you.
Ms. Novotny?
No, Your Honor.
All rise.